And I am back. Moving from the sublime to, the Hubble, or not the Hubble, but the James Webb Space Telescope, to more mundane. And it is, although the case involved that I want to tell you about now is serious down here on pedestrian planet Earth. But this is an opinion written by the editorial board of the New York Times. And the heading is A Dangerous Court Order Against the New York Times. And they mentioned that 50 years ago, and I remember this, you remember it, surely you're old enough, the Supreme Court of the United States settled a matter of when a court can stop a newspaper from publishing. And it was back in early in the 70s, I think in 1971, the Nixon administration tried to block the Times and the Washington Post from publishing what were classified Defense Department documents that detailed the history of the Vietnam War and all the lies and the deception and the bullshit that we, the American people, were fed by Democratic and Republican administrations for the previous, 20 years. Just absolute lies that cost the lives of 55, 56, 60,000 Americans, maybe 2 million Vietnamese. It was horrible. That was the so-called Pentagon Papers case, if you remember. The Supreme Court said, or the Supreme Court was told by the lawyers for the government that if these papers were published, this country faced a threat to our nation's security. So the Supreme Court had to make a decision. Do we believe the government or do we go with the free press? Well, obviously they went with the free press. And the Supreme Court at the time sided with the Times and the Post. And in a concurring opinion, and I think it was a unanimous decision, if I'm not mistaken, but Justice Potter Stewart wrote, quote, "Without an informed and free press, there cannot be an enlightened people," end quote. Well, duh. I mean, there are two things, in my opinion, that must be present if you're going to have a democratic government or a self-governing population. You've got to have an independent judiciary, but you also have to have an independent and free press. Take a look at Russia, for example. Russia has neither. China has neither. And they're both totalitarian, fascistic states. But anyway, that idea that in order to have enlightened people, you got to have a free and informed press, that's one of the oldest and most enduring principles in our legal system. And that is that the government can't tell the press what it can and cannot publish. And that idea predates the Constitution. But so there would be no mistake, the framers of the Constitution included a safeguard in the Bill of Rights anyway, the First Amendment, which says, quote, "Congress shall make no law abridging the freedom of speech or of the press," end quote. Very simple. All right? So that's why almost every official attempt by government to bar speech or news in advance, that's known as prior restraint, gets struck down by a responsible, legitimate, independent court. The court always says, no, you can't do that. The Supreme Court, U.S. Supreme Court, said in a case way back in 1963, quote, "Any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity." In other words, what that Supreme Court was saying, in my opinion, was don't even bring this shit to us because the First Amendment is pretty clear. And then Antonin Scalia, a generation later, wrote, quote, "Such restraints are the very prototype of the greatest threat to First Amendment values," end quote. And that is prior restraint, telling a publication what it can and cannot publish before it's published. All right, that's the background. This past Friday, however, a New York trial court, and this gets a little confusing because it's referred to as the Supreme Court of the state of New York, and it includes 62 different courts, one for every county in that state. It's not like, well, for example, here in Georgia, we have a Supreme Court. Below the Supreme Court are appellate courts. And below that, it works its way down. I'm talking about a state level now. The Supreme Court in New York is not federal, it's state. And there's one Supreme Court for each county in that state. Those are the highest trial courts in New York State. And they address issues of general jurisdiction. It's not constitutional issues. However, the New York Supreme Courts are not the last resort for the New York court system, as the U.S. Supreme Court is for the rest of the country. The Court of Appeals is the highest court in New York. Once the Court of Appeals in New York decides something, that's it, okay? I just want to make that sure because it's referred to as New York Supreme, one of the Supreme Courts. And it's different from the federal setup of the Supreme Court, okay? Okay, Jesus. Now, on Friday, a trial court judge at the Supreme Court level in one of the counties broke from the precedent of no prior restraint when he issued an order blocking the New York Times from publishing or even reporting any further on information the New York Times has related to Project Veritas. You talk about something misnamed. That's the fascist sting group that traffics in hidden cameras and fake identities and bullshit to try to target liberal politicians or liberal interest groups, as well as traditional news outlets. It's run, what's that guy's name? James something. He's been sent to jail, I think, a couple of times because he's such a fraudster. But anyway, the order from this trial court was highly unusual and astonishingly broad in its decision against a news organization, the New York Times. And it was issued by a state Supreme Court justice. Remember, there are 62 different Supreme Courts, one in every county in New York. So it's not as important, I guess is the right word as it sounds. But this Supreme Court justice named Charles Wood. Oh, and by the way, these Supreme Court justices in the state of New York are elected. They're not appointed and confirmed. They are elected, and I think they serve 12, 14-year terms. Anyway, this guy, Charles Wood, wrote that the New York Times decision to publish excerpts from memos written by Project Veritas's lawyer, quote, this is what the judge said, quote, cries out for court intervention to protect the integrity of the judicial process, end quote. To which your humble and obedient servant here would whisper horseshit. But anyway, the ruling follows a similar directive that the same judge, Wood, issued last month in response to a story the Times published that quoted from those very memos. And of course, the Times is going to appeal this latest bullshit ruling. I mean, that goes without saying. But in requesting the order from this judge, the lawyers for Project Veritas acknowledged that prior restraint on publication are rare, but they argued that their case, of course, fits a narrow exception that the law recognizes for documents that might be used in the course of ongoing litigation. Might be used. This is where the prior restraint bullshit gets a little thick. Now, this exception that Project Veritas's lawyers are talking about, the exception recognizes that because parties are forced by the court to disclose materials, in discovery, courts should have the power to supervise how such forced disclosures are used by either party when it comes to trial. The litigation here is a libel suit. This is what's involved. That Project Veritas filed against the New York Times in 2020 because the Times wrote a series of articles on a video that Veritas produced about what it claimed was rampant voter fraud in Minnesota, which didn't occur. So what Project Veritas wants is their lies to be protected. This is how fucked these fascist Christians can become. The video was, according to New York Times, quote, part of a coordinated disinformation effort, end quote. And the Times, in making that statement, the Times cited an analysis by researchers at Stanford University and the University of Washington. Those researchers took a look at this video and said, this is horseshit. But this is what the lawyers for Project Veritas asked the state Supreme Court, this one particular Supreme Court in New York State, to enjoin them from publishing anymore, to stop them. And this crazy bastard, this judge, this trial court judge, Charles Wood, went along with it. I wonder what his personal politics are, right? So anyway, where was I? Now, the lawyers for Veritas also argue that the memos are protected by attorney-client privilege, and that the New York Times was under an ethical obligation to return them to Project Veritas rather than publish them. Excuse me, that's not how journalism works. The Times makes judgments daily about whether to disclose secret information from governments, corporations, individuals, whoever's in the news. The First Amendment is designed to leave those ethical decisions to journalists, not to courts. That's what the First Amendment says. The only potential exception to that is information so sensitive, say, as an example, and this has been used over and over, if somebody knows planned troop movements during a war, we're going to move from point A to point B. And if that information gets into the hands of the enemy, then, well, you can project what would happen. So sensitive information like that, of course, is an exception to the rule. So the only potential exception is information so sensitive that if it's published, it could pose a grave threat to the lives of Americans or to national security. But that's the only exception that's been carved out to the First Amendment so far. Now, the memos that the New York Times has of this scummy, filthy Project Veritas, those memos are not a matter of national security. In fact, except for its ongoing libel suit by Project Veritas, and they're going to fail in that too, that group would have no claim against the Times at all. And according to this editorial, the memos at issue have nothing to do with that libel suit and did not come to the New York Times through that discovery process. How did those memos come to the New York Times? Well, through investigative journalism, against which there can be no, here we go, prior restraint. Still, these scum from Project Veritas are arguing that the publication of these memos must be prohibited because the memos contain, confidential information that is relevant to the group's litigation strategy, even though the litigation involved has nothing to do with what these memos show. The litigation that Project Veritas is involved in against the New York Times has to do with the charge of libel by Project Veritas against the Times for an article written, a couple of years ago. So the whole thing is an absurd bullshit argument, but beyond that, it is deeply threatening to a free press. Hi, Truth Seekers. Mike Malloy here. As you know, we've switched formats and are now broadcast exclusively on the Progressive Voices Network. So that means you get fewer program interruptions, no corporate commercials, and lots of profanity. But our format change also means some of our radio listeners no longer hear the program. It's been a while since I mentioned our podcasts, so you may have forgotten that there is a way to listen to this program anytime you need a good dose of screaming. Visit MikeMalloy.com and subscribe to our podcast. As a podcast subscriber, you can download the program to your mobile device and take me with you wherever you go. And if you have a friend who needs a dose of truth-seeking, you can give a gift subscription as well. That's MikeMalloy.com, and never miss a minute of the uncensored fun and frivolity.